get going here. We are it tonight. A lot of vacations and things. So let's get started with the, since y'all are both here, with the single family. I just called it single family one. I'm not giving it a name. I mean, that's what one of the things we need to decide on what we really want to call it. But this is for lots of less than 1 acre. And the big thing, what I did add in there, and I put the same thing in the PD, that bold sentence, this is a closed zoning classification that applies only to tracts or lots that exist or were created at the time of the incorporation.
Well, that's one of the questions I had. I didn't think we created anything when we incorporated. They were already there.
Well, let's see. All right.
But I marked that out because, as far as I know,
we
we didn't.
Existed.
Incorporation didn't create that.
Okay. Well, what it did was when I was going through those notes, then I thought, well, wait a minute. We're going to have lots, land, vacant land, and we, in theory, could have less than 1 acre with a house on it.
Yes.
Right?
Most
We should have, I mean, it's a property that was in existence at the time of incorporation.
Right.
But some of them are going to be lots. I kept, even at the top, I call it lots, but it should be district for tracts, I guess, maybe, of less than 1 acre.
Tracts, or you could say tracts or lots or improved sites, vacant. You could say improved sites as well.
Yeah.
Add that.
Yeah. No, I
So that's a question. I mean, so that really is a question for tonight, because I did kind of add that other category in there when I was writing it. It dawned on me that maybe we would have some tracts that had improvements. So we got to deal with those too.
Didn't we? I thought we discussed this, but this going back to talking about in existence at the time of incorporation. Is that the way it's going to? Is it going to fly that way, or is it going to be at the time the new zoning is adopted?
Ordinance? I don't know.
Because what does that do to anything that has happened between incorporation and say this?
I think most everything. Tom, help me. I think everything we've referenced incorporation. We don't reference the ordinance all the time.
Yeah, but I guess Brady's point
is
well taken. Is that between November of 20 and March of 24, that's kind of a no man's land. Well, and then really, if whatever they did in that point, we didn't have any basis for
yes. All right. So
complaining.
All right. So that's a good point. So what we should say applies to tracts or lots that existed or were created prior to. How about prior to the not passing? What's a better
Adoption?
Adoption,
which was March of 24.
Adoption, yeah. Of the zoning ordinance. Dated March 21st, 23 or 24?
I've got it here.
Here it is.
It's March. I know it was March.
3/24. Well, no, that's our date. Let me see if I can find an old ordinance here.
21st. March 21st.
March 21st of what year?
2024.
24.
Yes. No, the only thing is, or were created, or that were created. Well, first, we're in that first sentence where you said that existed before the incorporation of the town of Poetry, and I think that's also got to be changed.
Yeah.
To the zoning ordinance.
All right, change to zoning ordinance. Okay.
But then, or were created as a result. I don't understand how we created anything.
Yeah. Well, I mean, let's
created by division.
I see your point.
Right? Is what you're referring when you say created, meaning if something was subdivided. if you created a less than 1 acre lot.
But
Or maybe we change the word
They should have
created
been
to
allowed.
the or improved instead of created. Because that would indicate that improvements were placed on the lot.
But it didn't change the 1 acre. That was
No, it didn't change less than 1 acre.
Well, I guess my feeling is, just leave it. It's existed before the zoning ordinance was passed, March, or however we word
Take
it,
out created.
March of 21st, 24. But just that, because
Well,
the
but,
created is something that I don't see how we ever created anything.
well, we did not. Again, the word "created" is wrong. Is not a good word. We have to figure out something because see, lots of less than 1 acre were improved at the time of incorporation or at time of the ordinance. Zoning ordinance shall be deemed legally non-conforming or grandfathered. See, the problem is, so let's say we had a lot that was less than an acre, and they put improvements on there, but those improvements did not. See, if you just have a lot, you don't have to worry about setbacks. But if you have improvements on the lot, so in theory, we could have a less than 1 acre that had improvements placed on it prior to the zoning ordinance approval. Okay. But the improvements don't meet the zoning. See what I'm saying? So we got to grandfather those in.
Right, and I understand.
So that's where I was trying to get to.
But I guess, Dale, my point is it should, in my view, it's a period after zoning ordinance came in March 24, because created opens up a huge question as to what do you mean, and I just
let's
keep
change
it
the word
simple.
created.
It's simple.
It's improvement.
How could you improve it?
You put a house on it.
But
Put a mobile home on it.
but that wasn't.
But do we
So
not
1
need to
acre
protect-
lot with a house is an improvement.
The house makes it is the improvement. Or maybe how about structure? Can we use the word structure?
I mean, improvement's pretty common.
Yeah, as improved as a structure.
Yeah. When you improve a site, improve a lot, it's the addition of structures.
Okay. So I understand what you're saying about improvement. I like that word better than created.
Okay, improvement. You okay with that?
Yes.
All right, and the first one should be let's see, the second line, let's walk through it. Purposes only rights associated with legally created lots of less than 1 acre, and they were legally created because they didn't have zoning in place
Correct.
prior to the 1 acre that existed before. We could change before to prior. Should we do that or not?
Either way, I don't care.
Okay. The change in the approval of the zoning ordinance in the town of Portrait, or that were improved as a result of the incorporation. That doesn't read right.
No.
So that were improved
after
at the time.
Well, or after incorporation.
We wouldn't be after incorporation, but we're going to change that to zoning ordinance.
I mean, zoning ordinance. Yeah.
Okay, so we're approved prior to
the incorporation effort.
Yeah,
Okay.
prior to the zoning ordinance effort. Now, I may rework or take that word effort out. The classification is intended to ensure that such tracts or lots may continue to be used and developed without being rendered non-conforming or unusable solely because they do not satisfy the minimum tract or lot size requirements otherwise applicable under this ordinance.
Now, where are you reading right now? Which?
The next sentence, I'm just reading down, right? The sentence right before the
Okay.
bold sentence.
Okay, I see. Yeah.
All right, this is a closed zoning classification that applies only to tracts or lots that existed or were improved. Again, we change that created to improved, right?
Right.
Yeah. At the time of adoption of the ordinance.
Okay, now let's go to the next and let's read through it. A lot classification, a single family one, again, we got to talk about the name, that was vacant at the time, shouldn't be vacant, or improved. At the time of zoning ordinance, town zoning ordinance must comply. Oh wait, no, that's a different point.
That
It must comply with all the, all right. So lot classification that was vacant at the time of the zoning law, comply with this. In other words, the point is, if you're going to take that less than 1 acre lot right now and improve it, you have to meet the setbacks.
correct. Yeah.
Okay.
Yeah, I understand now.
In Exhibit A. And again, I'm calling it Exhibit A because the old ordinance has an Exhibit A, assuming that that doesn't move. Are we?
Right. We'll still have to have that
That'll be on the final draft.
with the table of
Yeah. Of this ordinance before improvements may be constructed on the lot or tract. Lots of less than 1 acre that were improved at the time of the zoning ordinance shall be deemed legally non-conforming or grandfathered and shall be considered lawful unless, regardless of whether they comply with the setback requirements.
Okay,
set
now
forth.
that sentence,
it's
to me, it has to be improved either before or after, not incorporation, but
Well,
the
no,
zoning.
let's say you have a lot right now of less than 1 acre. Now you want to put a mobile home on it. But if you're going to add improvements, take it from a lot to an improved lot, then we need to make them
you have to comply.
comply.
But the
we
second
don't
part,
want them to create a legal
Right.
non-conforming.
But it's a phrase at the time.
Okay,
that were improved at the time, meaning
it didn't have a house on it at the time of the ordinance. Had no improvements. It was just a vacant lot.
that's the first part of the section. The next part, you're talking about lots less than 1 acre that were improved at the time of the zoning ordinance shall be deemed legally non-conforming, regardless whether they comply or not, because
Right.
those cannot be changed.
You see what I was trying to do? Because it kind of blew up on me. Oh, wait a minute, we got to deal with both.
Yeah,
of them.
yeah. You address both parts. You both vacant and improved.
Do I need to separate that a little bit and clean it up, or
Yeah.
You could do a new paragraph.
new paragraph?
That would
All right, I'll put a new
where it starts with lots or less than 1 acre.
paragraph.
Yeah,
I'll split this paragraph into 2 paragraphs.
that'd make more
Okay,
sense.
but then here's my question.
Okay.
Lots of less than 1 acre that were improved before zoning,
At the time of the zoning ordinance.
but they wouldn't happen the day of the ordinance.
But they were already improved.
Well, then it's prior.
Prior to the zoning
Okay.
ordinance.
Prior to
Prior,
the zoning
prior is a good word.
ordinance.
All right, let's see where I'm at. All right, so lots of less than 1 acre that were improved prior to
Yes.
The zoning approval, and you can just leave it
to
short.
the time of the zoning shall be deemed legally non-conforming or grandfathered and shall be considered lawful regardless of whether they comply with the setback requirements. So yeah, I see. I'll just separate that into 2.
Okay.
We'll talk about a vacant lot and we'll talk about an improved lot, a new improved lot. Now you have a vacant lot. I need to probably flip that. Now you have a vacant lot that had a house on it. It's grandfathered in. It doesn't have to meet all the requirements. Now you have a vacant lot that you're going to improve with a structure. Now we're saying, but if you did that after March 21, 24, then you have to meet all the setback requirements,
Mm-hmm.
right? Because we don't want to let people create non-conforming lots.
Right. No, I get it.
And at some point, are we going to address destruction of improvements on non-conforming lots, is that going to be part of this?
Well, let's go ahead and read this. If we don't, we'll generate a paragraph.
What, by the way, what I would say in the very first part, with the first time you mentioned zoning ordinance in March 21st, 2024, put in parenthesis zoning approval or something. Then from then on, it takes on that definition of what happened on March 21st, 24. No, there's a legal way to shorten this. So right at the very,
why not say zoning ordinance ratified on
well,
or approved on? Ratified is a good word, isn't it? Ratified.
Did the council ratify? Did they adopt? Did they approve?
It was approved.
Ratified.
It was an ordinance. So just approved as a general word.
Ratified ratified. On. I'll rework that word. I get your point.
Right, but then from then on, just have a shorter phrase.
Yeah.
2 words.
Yeah.
Max.
Yeah. Zoning ordinance.
Right.
Okay. And I might end up putting that further up.
That's what I would do up in the very first part.
On that first sentence.
The first sentence, and then put parentheses zoning approval or something to that effect.
Okay.
And then from then on, just refer to zoning approval to rather than restate March 21st.
Okay. We'll clean that up. Split that next paragraph. Then on submittals, let's talk about this. A request to establish or modify a use on a tract or lot within the zoning classification must include sufficient documentation to allow town staff to verify the date of lot creation date of lot creation, and if applicable, the date on which any improvements were constructed. So that kind of covers both scenarios.
Yeah, I get you. Okay.
Okay, is that okay?
Yes.
Yeah, I didn't like it at first, but then I see your point now.
Okay, assembly requirement, and this was, I think, one of your comments, which I thought was a good comment. Property owners of a legally created lot containing less than 1 acre shall not be required to assemble adjoining lots under common ownership solely for the purpose of satisfying the 1 acre minimum lot size requirement.
Yeah. Okay, I agree with that. That's fine.
All right. What do we want to call this district? Let's give it a name.
I thought we did that last time. I thought we
talked about it. I guess my question was, did we all agree? And I couldn't.
It's been back and forth, single family. Scott threw out single family, grandfathered, single family GF.
But let's give it a name.
Well, I guess to make it very clear, it's single family grandfathered.
Well, but there's a bunch of different classifications. You could grandfather a 2.5 acre that doesn't conform. You could grandfather.
Yeah, that's true.
I'm thinking we call it single family 1. It's the lowest denominator.
That's fine.
I mean, that's where we've been most of the.
And by the time we get through with this, we'll change everything a dozen times. But if we start off as single family 1, and I will write out 1. Maybe 1 and then parentheses. District for lots. Or I need to put tracts now. I put the name up there first before I typed anything. Tract or lot of less than 1 acre. Y'all good with that?
I'm fine.
Yeah.
I fully realize once this goes to the council, it's going to be edited even heavily.
Oh, yeah.
So,
all right, well, let me tell you guys
so
this.
I don't care.
I talked to the mayor, just to let y'all know, and Tom, it's really your suggestion. I told Mike that once we get, in fact, this one and the PD will probably be on the agenda in the June meeting.
Okay. I'll keep it shorter.
Yeah, so we're going to be able to take pieces every month. We'll have pieces that we completed, take it to council, at least let them get a look at it. Because you're right. Once if we just surprise the council with the whole ordinance, it's going to be a bloodbath.
Well, it'll be a long meeting too.
Right, and long meetings, that way, well, that would be a workshop, but that way we could talk about it at the meeting, take their comment, tweak it.
Yeah.
Then in 6, 8 months from now, when we go through it, remember y'all kind of
Yeah.
approved, this is what you approved.
Yeah,
We kind of
yeah.
agreed to,
And
but
what
it's
did
not it wasn't a final improvement.
And what was Mike's comment?
He was okay with it, because
Okay.
I told him it was your idea.
Well,
But it's a good idea.
yeah, keep the meeting short.
Keep the meeting short, and let's get some of this. Get it.
little-
They need to get it in their head while we're trying to get it in our head.
Yeah,
I think.
it's like that saying of how to eat a whale.
Yeah,
It's one bite
Right,
at a
so
one
time.
bite at a time. All right.
Yeah, I like that.
Now, the
So-
other thing I was talking about was if we're talking about non-conforming structures, it's like any structure, a structure that is occupied by non-conforming use, destroyed by fire, act of God, or other cause, may not be rebuilt except to the provisions of this ordinance.
Well, we're gonna cover that under grandfather. That's what I thought we'd do, because
A separate,
yeah, in other words, and expand the grandfather definition and throw that in. You're right. Because what I'm trying to do, again, most towns will have COs, certificates of occupancy. And what you do is you issue those certificates of occupancy. And once you do that, if something is destroyed, a legal non-conforming use is destroyed, that was grandfathered in, they're allowed to replace with the same improvements. They can't overly expand it unless it meets the ordinance.
well, it's based on percentage. If it's destroyed to, like this
Right,
one
well,
was, for
we-
instance, 60% of reasonable value,
Right.
it can be rebuilt. If
Yeah.
it's beyond 60%, then it must be torn down
Yeah.
and built to
Yeah,
conform.
and when we get to that non-conforming definition, I agree with you. That's when we expand that language in the non-conforming part of
Yeah.
the ordinance. I think if we do it now, I'm kind of thinking we keep these basic classifications kind of short and sweet, and then cover all of those what ifs in the other sections.
It's okay with me.
Because you go to some towns, it's 3 or 4 pages on single family. It's like, my God,
Yeah, no, this is going to be enough for the meeting.
I think this is enough for the meeting and enough. And again, it'll be tested now. This has never been tested. It'll have to be tested, and then some future committee will change it again. But that's how it works. That's just what happened. Okay, so I will take this
Okay, sounds good.
and redraft now. So let's go to PD.
Okay,
Y'all take a look at that.
I did.
Yes,
You got front, back. I don't know if y'all.
I did.
Okay. All right. And I understand this. Sometime in the future, Portrait, in theory, could have a new development come in and want to do planned development. When we do that, then that name would be PUD, Planned Unit Development, or some towns use Planned Residential Development, Planned Commercial Development. They have all of those. In fact, you see the signs in Rockwall, and the way you've seen almost every one of them is changing it to a PD. So there's other phrases that we can use when that happens. I just thought we'd use a simple PD for that grandfather property, the grandfather subdivision.
Okay.
All right, so let's go through this. Tell me what you think.
Well, I guess starting off on purpose,
Okay.
that when you come down and say, okay, planned development zoning district identifies platted subdivisions within the town of Poetry that are subject to recorded deed restrictions. And I would just have a period there, because you said, and clarifies how those deed restrictions in this zoning ordinance apply to the affected property.
All right.
I don't know that we want to get into all that.
Okay,
That's
let me read it the way you're looking at it.
after deed restrictions, period. I would, on that sentence.
Okay.
Then
All
the next sentence I didn't.
All right, let me read it.
Okay.
Planned development. Zoning. Okay, let's just, let's hold that, because I think we cover it further in, but
Okay.
let's come back to that line.
But then here, the last sentence in that first paragraph on it says, this is closed zoning classification, town only to, applies only to subdivisions that existed at the time of the town's incorporation in
Yeah, we'll
220.
change that to zoning ordinance,
Is that town's ordinance,
Yeah.
zoning ordinance? Yeah.
321-24. Right. You're right. All right. So again, I'm not saying we changed paragraph 1. Let's read the whole thing and see what the first sentence should meet what we change going forward and come back to it. All right.
Okay. Under B, applicability, I didn't have anything.
Town's zoning ordinance. Each tract or lot within such a subdivision shall be. Yeah. For the purpose, just leave it at that. Because, we're going to have deed restrictions that say the only deed restriction is minimum building size. That's all. And you're going to have some like Grande Verde that's 2 pages long. You're going to have Hidden Oaks that's a page long. They're all going to be different. It doesn't matter. Since we're not enforcing deed restriction, all we have to do is at least look at those deed restrictions with the zoning and figure out what's the best thing to do.
Well, that's where I don't agree. I mean, why should we be the arbiter of that?
We're not. We have to consider them.
Why should we consider it?
We have to. If you read,
Why?
even Berman said it in his things, you have to weigh it. Yeah. And now y'all may not have all of that.
Well, I
Then
think I
we
do,
went through-
but I don't remember him saying we have to waive it. He said
Yeah.
whatever they do, that's between them and the other property owners.
Right. We're not in. Well, and again, when you take in that point, look down under I even say that we don't. We're not the
Right.
enforcer. It's somewhere
Right.
in here.
No, I understand. Yeah, you do say we don't
Yeah,
enforce
we
it.
don't enforce them, but
That's under Part C.
we have to consider them.
Why? I don't get that.
Because they're
Considering-
they're deed restrictions. Deed restrictions run with title. We can't change those deed restrictions.
They're addressed at different levels. Zoning is addressed to the city. Deed restrictions are usually addressed within a court. I saw something the other day. A man had replatted a bunch of lots together, and included in what he bought was what was said to be green space, deed restricted green space. He got permits. He received permits from the city to build.
Mhm.
He built the structures, a guest house and a pool, different
And
things.
the HOA.
Came in and sued
Nailed him.
him, and he was ordered to remove the structure. They claimed the structure would cost him $800,000 to remove. He's
Mhm.
decided to leave
Wait
it.
a minute. Zoning.
He's sitting in
Town
jail
approved
in
it.
contempt of court because he will
Yeah.
not do
And
that.
that's what we're trying to avoid. Is
But the
those
city-
court cases.
But the city, they did what they were supposed to, but they did not advise him because they cannot legally advise
Advise them.
anyone
On deed restrictions.
on the deed restriction. So when you say consider, how does the town consider it without getting into a
Trouble.
position of where you're advising or
Right.
asking them, well, why aren't you doing it according
Right.
to your deed restrictions? And if they say I don't want to,
Yeah, but
you
we
say,
have to consider, because just like that house right down the out in y'all's neighborhood, right there in that curve, they it was an estate,
Right.
and they split it, and they were going to split it where the house was, and it was going. The deed restriction said a 20-foot side yard setback. Okay, our zoning ordinance said 5. Originally, the way they subdivided, they met the zoning, but they didn't meet the deed restrictions. And so you take the more stricter requirement, which is the deed restrictions that is 20 feet.
No, I'm not disagreeing with you
So-
on that. I'm just
I
saying.
mean, that's an example of how I mean, we have to look at the deed restrictions and the zoning, and just like the deal in Hidden Oaks the other day, and meld that and come up with the best.
Well, that's where I don't agree. I mean, I don't see that we're the
Well-
ones to do that. That's the owner of the property to do that. Now, you know, Mike's letters normally have that statement of be aware of any deed restrictions or something like that that you're responsible for.
Right.
In other words,
No.
and we don't, in the letters approving some kind of zoning, we don't come out and say the deed restrictions. We just say it's your responsibility or something to that effect.
Okay, so here's Berman on April 23rd of this year, a month ago. Mike, being the mayor, questions relating to zoning should typically be resolved in favor of the property owner and against any strict interpretation of zoning regulations. If the deed or plat shows a property boundary includes half adjacent street, oh, that's a different, but it's the same. This was on that Hidden Oaks deal, but it's the same thing. When you get that cloud, you tend to want to lean towards the citizen.
Right.
But like on the 20 acre, see what I told that guy down the road from y'all is, look, do 20 feet, then you've satisfied the deed restriction, and the town, we're happy because ours is only 5. Don't get yourself in trouble with the HOA because you're just trying to follow zone. And the thing, it was an easy fix because they had plenty of land. In fact, they didn't draw the line. They drew the line at an angle to where that angle, when it got to the house, it was 20 feet. So they didn't really give up or gain much land, in the estate.
Right.
Because the estate wanted to sell the house, so they were willing to give up. So it all worked out.
No, I don't have anywhere that Dave says, David Berman says we need to be giving any kind of ruling or on zoning deed restrictions. He says, this is Mike, this is on his January 15th, 26 email. Dave Berman says, Mike, sure, we've had this conversation before, but deed restrictions are independent of our zoning regulations.
Mm-hmm.
Deed restrictions exist by contract between the property owners and have no influence or effect on municipal regulatory authority.
Mm-hmm.
Our zoning regulations apply regardless of what may or may not be allowed by deed restrictions. So the answer to the property owner should be the town's only concern is compliance with zoning.
Right. But do we want to put the enforcement officer?
Oh, we don't have one.
We don't have. Well, you and I are the enforcement officers right now, and Mike.
With zoning,
For
yes, for zoning, not
Right, not for
not
anything
deeds.
else, just for zoning. But that's the thing. If you study all of this, I mean, here's a note that I found. For zoning, this was zoning changes. Help staff determine which deed restrictions apply. And if there's
who is this from?
this is online,
Oh,
and I can give it to you if you
no,
want.
no.
Ensures council review this is what we're trying to do. Ensures that council reviews the correct combination of zoning and private rules. That's what we're doing with the PD. What the PD is going to do, at their zone PD, when they come in and do something, Teresa's going to see that, oh, it's zone PD 101. And the light comes on that we have more than zoning. And our job then is to figure it out or talk to the people and gather all the evidence. We just have to dig deeper.
Well, that's where, to me, you get into a legal problem. In that if we miss it or do something wrong or give them some other analysis than what's really there, or maybe there's a new
right.
type of deed restriction that's out, then we've taken on some responsibility where we just, if we just say it's your responsibility, figure out the deed
Look,
restrictions.
we're sitting here hours and hours doing it, and we're going to expect the citizens to figure it out.
Well, yeah, it's their business.
Okay, well, who are they going to lean towards their position or the town's position?
Well, it's whatever is most restrictive, but we have, that's what they can do, but we have the zoning restrictions, and we can give them that clearly. We know that.
No, we know that.
But we don't know all of the deed restrictions, and we don't even know that we
we'll
have the
gather-
latest
we'll
for
have to
all of
gather
them,
'em.
or the interpretation of them. So I don't like having us do anything reviewing deed
But
restrictions.
this is still a better position. How many conflicts would we create if we said, "Oh, you go figure it out yourself," versus follow, this is our zoning, and when they bring it to us, what most towns do is, okay, go to your HOA and get us a letter first that they approve these plans, all right? If the HOA agrees with the site plan that you submit to us, and we look at it, does it meet the zoning requirements?
Well, an HOA is different than deed restrictions.
Well, whoever manages the deed, sometimes the HOA does, sometimes it's architect control
There you
committee.
go.
It's
Then-
all different. But the thing is, go get that approval from them. If they approve it, then we're going to say, okay, they approved your site plan. Now at that point, we don't look at deed restrictions. Then we're just looking at zoning. But you're going to have some subdivisions that don't have that governing body. Okay? And all we do is, just like the other guy says, if you want to stay out of trouble, make that side setback 20 feet. Because what could burn you? And he was a flipper. He bought the house to flip. I said, you're going to run into this problem very soon. A title company, an attorney could find that discrepancy, and whoa, you've already bought the house, you've already subdivided it,
Mhm.
and it doesn't meet it.
Mhm.
Our job is not to say shall, it is you might want to make it 20 feet, because if the deed restrictions say it's 20 feet and our requirement is 5 feet, then you're good. And that's what it's designed to do. We can't make the citizens interpret that from themselves. You're just going to create.
Well, they can hire a lawyer. They can go to anybody they
What do
want.
we do?
But we are getting towards trouble if we start interpreting a deed restriction and we don't even know that it's the latest deed restriction.
We just have to look at them. You're
right.
just looking at the deed restrictions.
No, I don't like that idea.
Then they have to go in and produce the evidence.
That's right.
And it might be, and our first response is, go get the governing body to approve your plan.
What if they
Because
walk in?
this doesn't meet our zoning.
What if they walk in and it meets our zoning, but they say that it does not meet their
They could do just what Tom said. They could go do it anyway
right?
and meet our, in other words, meet our zoning. Let's say the deed restrictions are more restricted. Okay. The whole spirit of all of this is you lean towards the more restricted set of rules, right?
Yes.
So if they want to, we would never, the idea is we would never tell them just to go do deed restriction and just do zoning. If you read, if you do all that, I've studied this and studied this, it says the idea behind all of this is you've got to merge all of that together, the two systems.
But I've dealt with Garland before, and they've been real nonchalant, and they say it's not our problem. For instance, a house built in the 50s that overstepped its deed and setbacks and things by 5 or 6 inches,
Okay.
and the city was disinvolved. They could care less, but title, lender, all did.
Yeah.
On that side. And title attorneys, they cared. But then you go back to the cities, they're like, well, we don't care. It meets our zoning.
Yeah.
See, to me, that's our only rule, is does it meet our zoning?
See,
That's the only one we
the city
can
would not
enforce.
advise me on that.
We can't enforce, and this is, I put it in there, we can't enforce deed restrictions, but we've got to do the study and tell them where there's a problem. They don't have to do, as long as they meet our zoning and they want to go do something else, then then we don't say you have to. You say that's it. And-
Dale, I don't like the idea
I know
of
you
us
don't.
getting, that's the only thing I don't agree with.
But
Just leave it out is my view.
you're going to find this in every zoning ordinance. Take any town you want, and you'll find it in every one of them. Because
Well-
it's that big of an issue. Because deed restrictions run with title.
I'm not saying they don't. I'm saying it's not our business to interpret.
Yes, it is.
I don't agree.
Then why does every town have it in their zoning ordinance?
You can have it in your zoning ordinance,
Why
but it
do all of
doesn't
them
mean
have it?
that we have to interpret it.
PD zoning these days, and in the creation of new PD zoning, the developers have to submit all their paperwork, what they want to do, all their plats to the town
Mhm.
to create the PD. The PD,
That would be a
101.
PUD.
it could be. Planned unit
but we're
development would
talking about
apply to
PD.
something with the homeowners association and all that stuff. But planned development, all those types of zonings are flex zoning that can incorporate various uses and things
Right.
that wouldn't comply under a normal zoning
All right,
classification.
Yeah.
So I understand that. I just,
All right, let me play devil's advocate. I'm in a subdivision with deed restrictions. And what if the citizen says, I don't care about your zoning, I've got deed restriction, and I can show you court cases where they override zoning. Now what do we do?
Well, of course, if they're more restrictive, they would override zoning.
But they're interpreting that, we're not. So do we sit, what the point is, what it forces the two parties to come together, the town and the property owner, it forces them to come in, and they can bring it to council. What would happen, you have a board of adjustments, you bring it to the board of adjustments. They make a recommendation to the council, and it's worked out, it's negotiated, whatever. But it's worked out where both parties are happy and both sets of rules are satisfied. That's what you have to do. Because what the argument will be, okay, which one of these is more restricted? And that's going to be Board of Adjustments decision or the town council's decision.
No, I don't agree.
Well, I mean, that's how it's done everywhere but poetry then.
I don't agree. That's a legal issue, and that's something that we've gone through
And
with
we've already,
Mr. Berman.
yeah,
And he has not agreed with that we should be reviewing it. He said we are only responsible for zoning. There's nowhere in any
once
email
we
that
get
I
this
have.
written up, you're right. Once this is all written up, then it goes to Berman and see if this satisfies his belief. Everything's going to be reviewed by the attorney. The whole ordinance is going to be reviewed by him. Everything. I sent a request to Mike today. Look at, as an example, 6.3 of the zoning ordinance. I said, Mike, take 6.3 out of the zoning ordinance, take it to Berman and get his opinion. Now, why do we want to rewrite it? If let him tell us that maybe it doesn't need to be written, it's okay. And it's about, 6.3 is about, can't have any utility transmission lines or sewer systems or anything in the town. My question to Mike was, can we really restrict a utility as a town?
I wouldn't think so.
Well, they've got eminent domain.
Yeah.
And so I think the answer is that they
Right.
can use eminent domain.
Right.
But that's is a legal question too.
That's why I'm sending it to Berman now before we even mess with trying to rewrite it. Let him give us an opinion.
Well,
But that's what you got to do. Some of them are going to be that way. When we write anything, everything's going to go to Berman.
but here's the problem, Dale, is that right now you're the only one on the council that is willing to look at the deed restrictions and interpret.
Mhm.
Say next year you're not on the council and we have this rule,
No.
then who's going to do it? Nobody.
Well,
We don't want to have anything in here that's just applying to you.
So
Now,
let's
zoning,
let 'em-
yes.
let's let
Zoning,
'em-
we can interpret the zoning, but deed restrictions, no, nobody's going to want to get into
Well,
that.
you need to, and you have the right to call Berman and ask him. But with a PD zoning, Every town runs into this. We've got to deal with. If not, we're going to have. Well, you let him do it. Well, you didn't make him do it. You did this. We can't have that.
No. We don't make anybody do anything on their.
And we're
deeds.
not.
We're only responsible for zoning, and if
Right.
we get into interpreting them, we're asking for, to me, a trouble.
No, when that
don't do it.
situation happens, when they're going to say, "Oh, we're going to follow the deed restrictions," well, we're going to. At that point, if it becomes a fight, then yes, then all you do is you're only going to look. At the end of the day, if we get into a pissing match, all we're going to ever do is look at the zoning ordinance,
And that's fine.
and if it comes to an impasse, that's what would happen. Because then all we do is say, "This is what we are," but you're running risk, and we just told you about the risk. But everything you want to do meets zoning, and we're okay. At that point, if they say, at that point, then you're right. Our decision would be zoning ordinance. And if you want to do that, take that risk, knock yourself out. That's what happened.
Well, we can interpret the zoning ordinance, and anybody on the council can do that, but nobody else other than you can interpret deed restrictions.
No,
And we don't
the
want to get
attorney-
into
our
that.
attorney can.
The attorney'd have to.
He's not on the council.
Yeah, but he can give us an opinion. He gives us opinion every day.
No, he
That's his-
doesn't.
yes, he
Only
does.
when
That's
Mike
all-
asks him.
Well, yes. If he's asked by the town council or the mayor, he gives us opinions every day. Yes, he has to be asked. He doesn't say that. That's the only point. Well, then I say, let's go ahead and finish doctoring this up, and we take it to council. Let them decide that.
Okay, well, I will say in the council, I don't
That's
agree on
fine.
this, and I'll say why.
Yeah, and you have every
This-
right to say that.
Well, of course, but
Yeah.
I don't see this as something we need to get into, and I don't see anywhere where Mr. Berman
Yeah.
has
Well,
authorized it.
let's do this. Let's tidy up this document. Next meeting, of course, we would have hopefully Robin here, where she's got some experience with that, and let's get with just three of us here. This is something. Let's clean this up and give them another draft at the next meeting. Fair?
Okay, my only thing I would say is on these places where you have applicable deed restrictions
Mhm.
and something about deed restrictions is to put that in either yellow or highlight or italics or underline or
All right,
something.
so where's that
to-
at? Let's
What's all
look at
through it? It's every one you go through.
Well, you have them highlighted already.
Yeah.
Okay, tell me where's the first one.
Okay, the very first one is under purpose, where it says at the end of the sentence, I would have it as that are subject to recorded deed restrictions, period. Then I would say underline or highlight and clarifies how those deed restrictions and this zoning ordinance apply to the affected property.
All right, look, walk me through. Where do you, line 1, 2, or 3? Where do you start?
Okay, start with the plan development, and come all the way down to the third line where it says deed restrictions. And everything,
Second line, deed restrictions. All right, Texas.
well, on mine
That are
it's the third
subject
line.
to recorded deed restrictions.
And then everything, and the rest of that sentence, not the paragraph, the sentence is to underline or highlight and clarifies how those deed restrictions
How
and
you
this
meld
zoning ordinance apply to the affected property.
it's how you meld them, how you put them together.
I'm just saying, I'm not going to just highlight it or underline it or something, because I'm not going to agree to that. That is too much getting into a legal issue or a legal problem for us, and we should not be getting into.
Well, and that's why the document will go to Berman.
I'm saying, if you want to do something that satisfies me, just underline
Okay,
it.
that's fine, but ultimately it will go to Berman. All right, listen, let me read this sentence here. PD zoning affects zoning changes that require that both deed restriction and here it is. PD zoning affects zoning changes by requiring.
Which
both-
one are you on?
I'm on some of my study notes. Require that both deed restriction and town zoning regulation be evaluated together. And
By
I can-
whom?
By the governing body of the town.
No, we don't have
This-
that capability.
Yes, we do. We can hire a third party has that ability.
This is not what we can do. This is what we are doing right now.
Well, let's take it to the council. And before any land use modification is approved, this dual rule structure leads to more careful review. And here's really the purpose. More careful review ensures subdivision level restrictions remain recognized and guides council and staff towards a balanced, well-informed decision. And that says it all. And that's the whole purpose behind this, is that we at least look at it and we make a balanced decision.
No.
If somebody objects to that balanced decision, then okay, meet zoning and you deal with your deed restrictions. We don't care. That's
No.
we're not enforcing deed restrictions. We're saying as long as you do zone at that point, if they want to fight it, we say, well, we're not approving anything that doesn't meet zoning. You go do whatever you want, and you take the risk is all on you. And all of that is recorded. All of that is noted in the file, and we're covered.
So it sounds like it sounds like a lot of hoops to jump through to get to a point of saying there's nothing we can do about it.
No, we ultimately, if we get into the fight, ultimately we're going to stand our ground on zoning.
On zoning, yes. But all the talk about the deed restrictions and all the considerations, and if they don't want to follow their deed restrictions.
Yeah. And then at that point, our position is we're only looking at zoning because you don't agree with this. You do whatever you want to as long as you meet zoning. You take the risk of dealing with deed restrictions.
Right.
But we're never, ever, ever going to take the risk of deed restrictions. But at least the file, the hearing, recording are all the evidence will be there. So if they get sued or title company says this or attorney on the other side, when they sell the places where you didn't do this, this, and this, it's their problem, not ours. Because you met the zone.
Well, and what you say, yes, and in a way could protect the town,
Mm-hmm.
if the town interpreted them correctly.
But this is what's been happening so far. We just look at zoning, you have deed restrictions, and we're giving people bad advice. That's the problem.
We're
So
not
we're
giving
ju-
any advice on deed restrictions.
Yes, we are, because we didn't tell them.
You are.
Maybe
Nobody
me.
else.
Yes, and we have to do that. Unfortunately, Tom, we have a fiduciary responsibility to tell them that.
No, we don't.
Yes, we do.
Government's made clear we don't have that
well,
responsibility.
Let's take this, doctor it up, go through it the next meeting, and send it to Berman, and then see what he says. He's saying that because we don't have anything in place. Once we have something in place, I think he'll have a little different opinion. He'll have a different view. But
Berman
when you
gives us
don't have PD zoning, yeah, then we put our blinders on, we just deal with zoning. But we have already screwed people on this. And that's why we're trying to, and that's the whole reason we're even doing it, because we've already made mistakes.
That's nothing to do with the deed restrictions. That's zoning issues, which I agree we've had problems with zoning
But
issues.
the citizen is the layman. That is our fiduciary responsibility to tell them of the issues.
Not on deed
Another
restrictions.
deal.
No,
I
it
do. I got another deal that I've worked on, and he resolved it. I took him the zoning ordinance and the deed restrictions, and he says, "You got to figure. You give us a drawing of what you want to do, and we'll look at it. But you look at your deed restrictions along with it, and that there's nothing wrong with us telling them that. We're not saying you shall or you will. Ultimately, if we get into that." Ultimately, we're going to look at our zoning orders. We're not going to look at the deed restrictions, but it is our job to tell you you have those deed restrictions.
No, I don't have a problem with advising people to look at their deed restrictions.
I don't
If
either.
it's one line, it's one line. If it's 2 pages of legalese that's
Well, it may be pages, but it's only going to be part of one page probably
Right.
that's going to become the issue.
so then that becomes
It's not 50 pages. It's that one paragraph.
then when you're sitting with the landowner, homeowner, whatever, then they're looking at you for advice on those deed restrictions when
Well-
when your position really should only be, okay, here's our zoning. Have you looked at your deed restrictions? Oh wait, here I have a copy. There
And
you go.
our position would be,
And that'd be it.
our position then at that point is go get this approved by the governing body of your subdivision. And if they approve, it's just like a septic or just like a 911 address. Go get it approved by them, give me approval, bring up an approval letter to the town, and we're good. But we can't expect these laymen property owners, they're all going to, I mean, we got to screw up right now.
We're laymen. We are not the lawyers to do
At-
that.
Right. And at some point, when we're not, it's just like I had a culvert issue today. All right. The guy wanted to put in a poly culvert, the black plastic culverts, right? The rigid culvert.
Hunt County
And the
doesn't
question
allow
was
that.
whether it was the weight or something like that. And I took your position. I said, whoa, we're not at that pay grade to determine which is the best kind of culvert based on what you tell us is your traffic over that culvert. All we're saying on our ordinance, all we're saying is we approve the size and you have a limit of 60 feet on your length. But it wasn't the property owner. He wanted to put in poly.
Yeah.
Fine, as long as you meet our ordinance doesn't address poly. It's got some funny language in it. It basically says appropriate or approved.
What that comes down to Terry.
Huh?
It's Terry Fowler. When we agreed to that
It was
ordinance,
Terry
we
and I.
agreed that Terry, no, Terry.
No, Terry asked me to go look at it. Okay, but yes, it's Terry's in charge of culverts.
Yeah, I applied for a permit a couple months ago. I still haven't heard back.
Huh? When you did it, what?
I said I applied for a permit a couple months back, and I haven't heard back.
You haven't? Well,
No.
But-
Things move slow, you know.
but but the thing is, I mean, we've got people, Terry works, he's got a couple of jobs, Tracy works, the rest of us have got to fill in when that happens. You and I, because we're retired, we're kind of around.
Well, and things like culverts, and you just stay consistent. I mean, Hunt County has ruled the roost on roads and culverts and all that, and the town shouldn't try to reinvent the wheel on culverts when Hunt County has something in place
Right.
for that. It should
And,
just
and
be.
Tom, what I did, I went by and looked at it, checked the size of the existing culvert, because we wanted to make sure. I talked to Terry. All right, Terry, this is what it's going to do, blah, 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 blah. Here's the size of the culvert. I've been out there. I know water doesn't sit there. And he told me what to do, and I conveyed that to the property owner. So I'm not out there doing it by myself.
No, you're
I'm
doing what
going
Terry told
through
you.
Terry.
That's what we agreed to.
Right. And Terry's doing it. It's just Terry's job has
doing it
changed and his hours have changed.
temporarily. What we also agreed in that meeting was that eventually this was going to go over to somebody who, like our town engineer, or somebody who did do this routinely. Now,
Mhm.
in the cities, they have people that do it routinely and have standards set out by town engineers. They follow those standards.
Mhm.
We don't have that.
We're not an
But we
engineer.
agreed to go with Terry. I was against that because Terry's not an engineer either. He does have experience. So we're
Mhm.
going to go with Terry because his experience is
Mhm.
there.
And I have
But it's
experience
not-
too.
No, you don't. It's-
With
we
putting
agreed
culverts
with
in,
Terry.
sure as hell do. I bet I put in 100 culverts. I was
Well-
a general contractor, for God's sake. I know a little bit about culverts. Okay?
Well-
Am I an expert? No. But I do know a little bit about
Well,
culverts.
there you go.
And I took all the
That's what-
information. I consulted with Terry. Terry agreed, and we agreed on what we'd tell the guy, and that's what he did. Now he gets to decide because our ordinance is absent of the kind of material. So, because we wanted a simple court, but if the guy, and he's a contractor, if the guy wants to put a poly culvert in, we didn't argue. That's not our point. We care about the flow, the angle, and the location
Well,
and
yeah,
the length.
that has nothing to do with deed restrictions.
Well, it's the same purpose, Tom. Come on. It's the same purpose.
No,
same,
it isn't.
it's the same process.
No. These
And
are
eventually-
legal issues that we don't have any
Well,
business getting into.
This
On
will
deed
go to Berman
restrictions.
before it goes to council. Final draft. It will go to Berman.
Well, I'm against it, and I'll
Okay,
explain
you
why in the
can-
meeting.
Let's go ahead and finish.
And I won't vote for it either.
That's fine. There's 5 people on the council. Let's read the rest of it. Okay. And well, I'll tell you this off camera. But for PD's zoned property, both this zoning ordinance and the applicable recorded deed restrictions govern the use of the development of the community. Town staff and the town council and property owners shall consider both sets of provisions when evaluating any proposed use or change in use.
And that's, I struck out town staff and town council.
We're just
It
evaluating.
just starts with property owners.
It's-
That's the first word in
right.
that sentence.
It's evaluating. That's all we're doing is evaluating. We're not making a judgment. We're evaluating.
No, you didn't. You said consider. Property owners shall consider both sets of provisions when
When
evaluating the
right.
proposed use or
Consider,
change.
not
But it
you
should
must.
be
No.
property owners, not
No.
town staff, and
Why-
definitely
why
not
don't
the
you
town
do
council.
some research on PD development? And if you go ahead and do some research, I think you're going to see it's the language. All right, let's read on. The town shall not enforce private deed restrictions. There it is. And nothing in this section shall be construed to authorize town staff or the town council to act as an enforcement authority of
Right.
such restrictions.
Right,
If
that's
that
clear.
doesn't say it, nothing does. Enforcement of deed restrictions remain solely the responsibility of the persons or entities
Yeah, I'm not arguing with that.
entitled
Of
to
course.
enforce them.
Right, I agree
That
with that.
says it all.
No, it doesn't, because the first part you're saying we do the valuation.
All right.
And we don't do the valuation.
All right. We'll take it to council and to the attorney. All right. Any word changes in that paragraph?
Take out town staff and town council. Start with property owners. Then in D, it comes down to the same thing.
I'll do a red line of this. Where deed restrictions govern the use of the development of the property. See? The applicable recorded deed restrictions govern the use and development of the property. They do. Town staff, council, and property owners shall consider both provisions. And again, the whole purpose here is let's find a happy point that we can both agree to.
So Berman says your answer to the property owner should be town's only concern is compliance with zoning.
Mm-hmm.
We don't evaluate deed restrictions.
Until we get a zoning section.
No.
Well, let him shoot it down. Okay, and next meeting we'll have hopefully more of the committee here, and we can do that. But let's look for modifications now, and move on, and have a better document to review at the next meeting. All right,
Submittals, same thing. Should end with the compliance with the zoning ordinance, period, not and the applicable deed restrictions.
There's nothing. We're not doing anything wrong by at least looking at the deed restriction, and that's all we have to do. You go back to the previous paragraph.
It says that must include sufficient documentation to
Mhm.
enable the town staff to evaluate compliance with the zoning ordinance and the applicable deed restrictions.
Mm-hmm.
And I took out and the applicable deed restrictions.
All right, why
It's
don't I
only the zoning
I'll
ordinance.
rephrase that to soften that up. Okay? And the applicable evaluate conformity or compliance with. And I'll reword that sentence to soften it up, where I'll find the wording. I'll put a rewrite on that sentence.
And in the staff review, it's the same thing. Town staff shall review the request for
For
consistency
consistency.
with zoning ordinance and the applicable deed restrictions, and shall prepare a report and recommendation addressing each if applicable. No,
Yes.
With only, it should stop with the zoning ordinance.
But there's no, well, we're not going to solve it. Let's take it to council. Okay? The town council considers when required by the zoning ordinance or other applicable laws, the town council shall consider the request in light of both this zoning ordinance and the applicable deed restriction.
And I
We'll
took out
consider.
both, and I took out and the applicable deed restriction.
Shall consider, didn't say will consider. And again, all through this, what we're saying is just don't go out there and just look at your zoning ordinance. Look at that. Is there a way we can make the two work? Can we satisfy both? At the end of the day, if it meets their site plan, meets the zoning, and they want to go do something else, then we're not going to say no. Even if what we approve, because it's all recorded, we all documented, if we approve the site plan that doesn't meet deed restrictions, then ultimately, if they want to fight it, we don't care what you do. Go knock yourself out because it meets zoning, but we're just telling you, you might have a problem down the road on title. And I think we owe the citizens that. And if we get into legal, we get into legal. But guys, we got to put our big pants on. This is our job.
No.
It
You're
is our
asking
job.
to be lawyers, and we're not lawyers.
No, you're going to get a lawyer. And if it gets to that point, we're both going to get lawyers.
Nope. We're not lawyers. This
We're
is not our
but
business.
we're going to hire one.
I think
You're
Berman.
getting into something that's none of our business.
You know, you better get to it because it's coming. All right. Conflicts of rule. If a provision is only on conflicts with the provisions of the applicable deed restrictions, the more restricted provision shall control unless otherwise required by applicable law, court order, or duly adopted ordinance or resolution of the town. What that allows them to do is bring it to Board of Adjustments and or to the council. So they have an out, we have an out. But ultimately, yes, if that set of plans meets our zoning ordinance, and when you want to go do something else, we're going to let you go do it.
Yeah, and I don't have any problem because you're not asking the town to do anything.
We're not. Yes, we are. The town is asking you to adhere to the zoning ordinance.
And that's all.
Right. And if you can tweak the site plan, again, it's setbacks.
Yeah.
Okay. What if they wanted?
I don't have any problem with that paragraph.
Okay. Each PD zone subdivision shall be assigned a unique number. Again, this is gonna take some time to identify all of the subdivisions. It's gonna take some time. And this will be a thing that we would put up at a public hearing, a community meeting. If you have deed restrictions, tell us about it.
Well, that isn't what it says here. It says identification and mapping. I don't have any problem with that paragraph, the way it's written.
Okay. But I mean, how are we going to do that? We're going to have to let the citizens know what we're looking for. If you have deed restrictions, let us know. I'll go pull them from the county and we'll make a file on it. And there again, it's all you're going to do is give it a PD number. Let's say they go in and change the deed restrictions.
Well, this doesn't say anything about that. It only says
we don't care if they change it.
But it's the way it's worded now. I have no problem.
All this does, PD tells you, shows you deed restrictions.
That's not what it says here.
Well, God, Tom. Yes, it does. Staff, all those people, you're saying those future people with the city, when they see PD, they're going to know they've got something. Bring them to me. Now, hopefully, most of these PDs we would already have copy of.
Well, F is only about identification and mapping. That's all it is.
Mm-hmm.
And I don't have any problem with the way it's written.
That, in other words, what we would do, let's take Grande Verde.
No, I don't have any problem. I'm okay with it, just like it is.
This right here, we would change this color, everything that's in the Grande Verde up to that house, and that would be a different color, and it would say PD 202. This Hidden Oaks, we'll figure this out. It'll be 201. Green Meadow. All of these subdivisions they would have their own PD number on the map.
Right.
That's again a way that we can identify the portions of the town that are encumbered with both zoning and deed restrictions. And that's what PD, that's what this is solely used for, is just to identify those subdivisions. And you take each case individually and you deal with it. But we owe the citizens to deal with it.
I don't have any problem with the wording on E or
Okay.
F or G or H.
Gee, all right, so we're done. We'll make these changes. I'll rewrite this one sentence. We'll change incorporation to deed restrictions, and I'll put that last sentence in bold, and then we'll look at it next month. Okay? All right. Next, and then any questions about the name?
No.
I don't have any problem.
Okay. Let's go to the zoning ordinance. And let's look at ag or agrarian right now. I think we talked about changing it to agriculture. Okay. A down and dirty, simple way to kind of resolve this thing. If you look on page of the zoning ordinance,
Page 5.
on section 7.1, page 5. All right.
Wait, page 5?
Well, it's page 5 of the zoning ordinance or section 7.
That's page 5 is two
Well,
point.
don't go with the page, go with section 7. You got big print, so it's probably not the main.
No, I've got this straight out of our
deal. Well,
what's printed
mine
off
may
the
be a
internet.
different.
That's our ordinance.
Yeah, it's fine. And mine might be a different, but I got the word version.
Okay, 7.1.
7.1. All
Okay.
right, so here's the deal. We get into this, we get really muddled into this. Your zone ag, but you can split off 2.5 acres, right? Not a big problem. But this is what's going to happen. What most towns do is zoned ag. If you have a historical agricultural use, the farm, you see it up on Dallas Tollway still, the Haggard farm up there. What most towns do is look, farmers, ranchers, go ahead and continue doing what you've been doing all your life and your grandpa did. You zone it ag. A ag zoning, you cannot go in there and build a high-rise office building. You have to go through zoning change. Even if you look at when properties are added to the town,
Annexed there, yes.
it automatically goes ag.
Mhm.
And that's that classification. Anything new or ag properties, it goes to ag. Now you want to change the use, you got to go through rezoning.
Even if it's 1 acre.
Yes.
Okay. I don't if
So what we would do, we would take out all of that 2.5 acre minimum. You're in ag. The only thing I could think where we might want to do in ag is maybe play around with the setbacks. Nothing closer than 200 feet to the road, and nothing closer than, say, I mean, I was reading one the other day. I think it was, may have been Parker. Nothing closer than 100 feet to the property lines.
Right.
After that, you go do whatever you want to do, you're ag. And now we could put some, and that's the other thing, we could put restriction on how many houses you can put on there. But in theory, if you're zoned ag, you can go pop out there 2.5 acre sites all day long. Do we really want that? I mean, a developer could take it and use it against us.
well, there's very few places you could do that here in Poetry.
2.5 acres?
Yeah.
But every one of the legacy families could do it.
I think one of the points I was trying to make last meeting was that if there's no restriction on structure or the number of homes, whether it's a home that's being sold or whatever, or rented or Airbnb, and they could line the road, they could line their
Yep.
the town
Mm-hmm.
with them
Right.
on their frontage. that's within the town limits.
Yeah.
If there's no restrictions on
Yeah.
the
But
number.
most of them with 2.5 acres is going to be getting into the ETJ. It's very few of that would actually be in the town.
And they can do that.
Now,
Right.
if you're talking about setbacks,
But-
setbacks would eliminate all of that. I mean, when you
Mhm.
say 200 feet, it's putting it out of the city anyway.
Your whole point in there, which I'm fine with, it's a temporary thing,
Exactly.
and call it agriculture or whatever we call it.
And the minute
then-
you want to change it or
And then
split
we
it
have to
up,
come back and ask for rezoning.
because, and that's what usually happens with towns is, you age out, becomes an estate, the estate immediately sells. That's what you want. What it would do is protect the town, in my opinion. It protects the town by giving it that very strict open ag zoning. The minute they do anything other than that ag historical use, they have to come to it to town.
Unless
that-
it's in the ETJ.
Oh, you're right, unless in the ETJ, but they're going to still, if a developer comes and buys the land in the ETJ, they're
So-
still going to have to come to us because they got to cross the piece that's in the town, and they'll have to come to us.
So here's an example. I took this a couple days ago out in the country. This is
Okay.
D.R. Horton, and this is what we have to look forward to. So you see the streets, and I should have turned around and took a picture of the development, but here is essentially our town limits. Let's imagine that curb is,
Mhm.
and then the road's out there. What did they do? They put in their retention pond right at the
Right.
street, ran a concrete street up the side of it, and then the rest of
Wildwood did the same thing.
the development is in ETJ, and
But
that one was built exactly as I had been describing.
But at least the town gets to look at it. They could go in there and carve off 2.5 acres and put a pond on it. It's ag. You're changing the use. You have to come talk to it. And it's really just a stopgap that developers who are going to go buy the ETJ land, but they're also going to buy a frontage because they need access by roads, and they're going to buy the part in the city. But it's all part ag. When they come in, anything they do on the town property in ag zoning has got to require a zoning change. Then that way we get to look at everything.
When somebody say they take that frontage and they dig a pond,
Mhm.
would that be a zoning change?
If you were using it for flood retention because you're selling lots in the back, yeah.
Flood retention or
Well, if you're building a pond
something
for
to look
ag,
at?
then that would be the thing. If you're building a pond for ag use,
Yeah.
watering your cows, okay, but you're no longer watering cows.
I guess what I'm getting at is how could it be restricted anyway? How could
Yeah.
it even be stopped? I mean, and even taking the drive, the road into the development.
Mm-hmm.
I mean, we can't dictate what can and can not
In the
Pass on that
ETJ,
road.
right?
well
Yeah.
pass
Pass
through the
city
town
limits.
and then go
Yeah.
to the ETJ.
But
So
all it would do is force them to come to us because it's ag, because literally everything with maybe the exception of a detention pond. And then maybe we need language in there about detention pond. It's one thing to have a pond, it's another thing to have a detention pond. Or retention pond. There's detention and retention.
yeah, detention, retention, one's dry, one's not. And that may be some kind of restriction that you can put in there. The zoning, how it talks about playgrounds and all these different things.
Yeah, see, that's
you
the
want to take all
problem.
that stuff out, which I agree with.
Take all that out.
Keep
Keep it simple.
talk about a restriction in the zoning that disallows those types of uses. No, I don't know, how would you word it?
Well,
The property is not non-permitted uses. Retention pond for a platted. development.
Well, and we just have to. We would, we're going to make this simpler. But you're right. Then you have to add a definition for detention pond versus a pond.
Flood control. I mean,
And
so-
quite honestly, a pond is retain a detention pond is
It just takes the place
Detain.
of city sewer.
yeah.
And,
Detain means you slow it down. Retain means you keep the water that comes
Right.
into it.
right. And developments have both. And I mean, they obviously don't have sewer to carry it to creeks, lakes, whatever.
Yeah.
So that's what they build.
No, with Wildwood on Poetry Road, that's exactly what they did.
Well, and it flooded Poetry.
Yeah,
Road.
yeah. Of course, they didn't because they didn't deal with the drainage issues. That was Rockwall County. But that's exactly what they did. We'll keep this simple. We'll put our detention pond on the road.
Mhm.
And so you're going to ride around Poetry and have nothing but ponds.
Now,
So-
back to your point about if they do it in ETJ and come through town, they have to come to us. Well, Bishop Fields, we're finding out they don't. They go through the town. It goes into 2440, one of the roads, and yet we have absolutely nothing to do with it. Just because it goes through the town doesn't give us any authority in
We
that.
don't have zoning in place to even
Right.
have that
but
authority yet.
What that little strip that they have, I think, is only 60 feet wide or something.
Whatever. It's a
It's wide
cut
for
through.
street, isn't it?
it's for, I think it's for a fire and emergency vehicles.
Yeah. Now, this is Bishop Field. They own property, that corner. They own that corner,
Well,
which is outside the city in the ETJ. But of course, they've already pulled out of the ETJ.
but 2440, it goes
over
into
here.
2440.
It's when
That one
right over
road,
here, right here.
and then we
Comes in
did
right here.
ask the question of Mr. Berman, is what control does that give us? And he said absolutely none.
None, because they only have 60. All they would do is come. Well, again, that's because we don't have an impact fee ordinance. You have an impact fee ordinance. Well, wait a minute. That little 60 feet is going to dump 2,000 day trips a day, and then therefore you owe us $3,000 per lot.
Yeah.
And that's how it's done.
Yeah, but that's not how we have it.
Right, because we don't
Whether
have
it's
an ordinance. for
Bishop
it.
Field or Daryl Jacks or Lamar Ranch, we don't have
That's
that
why
for
we're
any
trying
of
to
them.
get all of this kind of stuff in place now.
But that's an ordinance that we don't have.
We don't have it. And we got a bad zoning ordinance. We got to fix the zoning ordinance. Then from there, because I'm already doing the research on the impact fees, because that's going to be the big hammer that we have. And we've got to get there pretty quick.
Right, but
I
that's
hope to have the impact fee ready before we have
But an
zoning
impact
ready.
fee, I mean, yeah, you collect that money and that traffic is real.
It's real.
And that money's going to be gone before you know it on road
And then
maintenance.
what we do on 2434 is we go and take that bridge out instead of having a bridge in the middle of an S curve. Put a good bridge there, and and a bigger right of way, and we take that money from the impact fees to make that change. They pay for it.
Yeah.
Because
Well-
they're throwing 2,000 or 3,000 day trips onto that road.
well, the only right now, I mean, that's the future. Right now, the only thing we have is negotiations.
Right.
So
right.
we don't have any authority.
We don't have anything yet. Right. And that's why we're behind the 8 ball right now, because we don't have any of that in place.
But if we put in the impact fees, they're going to complain that, well, we're doing it after the fact. They're
Well, no.
grandfathered in.
Well, they haven't submitted their plans to the county yet either.
Oh, yeah, they have.
The actual plans,
Yeah, that's what was presented
the
in the
concept,
meeting.
a whole full set of construction plans or concept.
Well, they show the package that they presented in the meeting and that was approved by the TCEQ.
Yeah.
That has
yeah.
all of the layout of how many,
Lots.
acres and the density and all of that.
And I'm
mess.
not saying we're going to catch the first subdivision.
So
but
I don't-
let's
so I don't
catch
think-
number 2, 3, 4, and 100.
So I don't see. I think Bishop Field we're too
Maybe
late.
too late.
No, Lamar Ranch,
Mhm.
the Jacks, or any of these others,
Yeah.
maybe
Yeah.
get it in time.
Right. And the Lamar Ranch, they're just going to work around the part that's in poetry.
Well, it's a small part in
Very-
poetry.
yeah, very part.
Yeah.
And the Huntsville outspend us in about 2 minutes.
Anyway, so I don't have any problem with that about temporary step
All right,
zone ag.
So, all right, so we'll take the 2.5 acres out, and it's ag, it's ag. Anything you want to do, anything but ag, you got to come in for rezoning. Okay, and then all these permitted uses, scratch all of them.
Oh, you're talking about in 7.1?
7.1.
Yeah.
So rewrite the first paragraph, and I understand this is our first discussion about ag. Next month, it'll just be a first draft. We'll have 2 or 3 drafts probably before we're finished. And if y'all agree, then let's take 7.2 all the way to 7.26, take all of that out. We might leave 7.26. Well, they could come in for a special use permit. So let's take it all out. If you're ag, you're ag. If you want to do anything but ag, you got to come to the town for rezoning.
And do we have a proper definition of agriculture activity?
No, we need I'll do, I'll put it here. New definition.
But you don't think it should?
It's what I've read of most of our definitions, they just need to be a little more specific. I don't
Now,
think we don't even ag driveways. We have ag driveways.
Yeah, because of that distance.
That's it. That's all we have, huh?
Yeah.
So we need an ag definition anyway, especially
Right.
if we're going to change the ordinance.
Now, on permitted uses, I understand what you're saying, but then thinking back, I guess you could regurgitate the definition there. But does it go hand in hand that the uses are for a dwelling, single family dwelling, and or ranching?
Well,
I mean, it doesn't have to have a home on it, but
yeah, that's
Do you
one
put
of
it
the
in-
struggles that I've been, and I haven't reconciled it in my head yet. I think we do need some residential language in there. Should it be, I mean, a agricultural dwelling or a dwelling on agricultural zone property?
You're talking about definitions now?
Well, definitions, and I mean, we can't say you can't put, how many houses would we allow them to put?
that's still to be determined whether we can do that.
Yeah. Or should it be something like,
Well, I think that's defined for agriculture. How many houses can you put?
well,
It is right now,
it's 2.5 acres.
1 per 2.5 acres.
Okay.
So we want to take that out. But, and there's some I've read some ordinances where there's some better language in there for that.
Yeah.
And I can go borrow that. Because I agree with you. I mean, you don't want to restrict them too much, but you don't want them slipping in, wake up one day and there's 20 houses on the place. And it's
20
all zoned ag. That's what you want to avoid.
Yeah.
So I just think keep it simple, do kind of, and it seems to have worked for everybody on towns of just letting the true ranchers and farmers do their deal. But the minute you change it, you have to come to the town
Yes.
and let's not muddy it up with churches and parks and all of that. They want to build a park in the middle of their ranch, knock yourself out. Okay, height. We can cover, because I looked at the heights. What about a silo? We have one in Portrait.
I don't know if you can put much about height. You
Exactly.
talked about setbacks,
Right.
area coverage. You could solve a little bit of a development issue with area coverage.
Yeah.
Site coverage.
Yeah. And then the solid fence. I think the fencing needs to be a separate section in the ordinance. Because we have the same standard line.
Because it
in
applied to
every
everybody. Yeah.
zoning.
Well, yeah, all this stuff's been
Yeah,
regurgitated.
so I
throughout.
think this fencing needs to go under a different heading, and because The fencing portion of the ordinance is not sufficient enough
Yeah.
for all the what ifs.
And a lot of towns do that. They'll have that separate car storage, things like that separate.
Well, and what about a living fence? When you talk about a living fence, I'd rather see a living fence than a wooden fence,
well, you
a
can't.
hedge, or you can have barbed wire and T-post and a living fence.
Well, there in your definitions would have to be stated in there. Would a
Yeah.
fence constitute the fence?
See, that's what I'm saying. Our fence language is not adequate for, I think, what we really want to see in poetry.
But the solid fencing, I understand. I mean, a lot of
Yeah.
times you have solid fencing because somebody's putting a wrecking yard back there or something.
Right. Yeah, and that's where we talked about our last meeting. That's why when we get our next big one, obviously it's going to be business, office, retail, or whatever. Exactly, because we've got to be careful about parking and square footage and fire lanes and things like that, because what's going to happen is some guy builds a metal building, opens up a car repair. We all know what car repair shops end up with. 5 acres of things I'm going to get to. And that's what we got to fix when we get into that.
Park them in the ETJ.
Yeah. Yeah. You see that place on 276? Their whole lot is covered in cars.
There was an issue up in Cattle Mills like this on FM36, and it's gotten better. But this homeowner, and you'd almost think that it was a platted development, but I'm not sure. But it's house after house after house on several acres. The whole yard full. They go to auctions and fill them on cars, large pieces of equipment, trucks.
Oh, wow.
And they would back them up all against the property line of the neighbor there. And this is obviously out of the city of Cattle Mills, but nevertheless, this guy's out in the country doing whatever he wants. And they can essentially do the same thing here on a decent sized piece of land. Just move it to the backside.
Yeah. Yeah, and I'm all for a simple zoning ordinance. I got that. But simple is, we keep a very simple zoning ordinance, we're going to get eaten alive. That's an example of how we'll get eaten alive.
Well,
and part of it is our unique shape. That's our biggest, that's our biggest problem.
Yeah.
Because we only control 286 feet.
Yeah, that's why.
Okay, so we're going to take all of that. I'll rewrite ag.
7.1, 7.2.
Yeah, rewrite all of that.
That's
kind of play around with some of this other stuff. Because, the thing with the parks and the churches and...
Yeah, I agree.
That we probably need to add a classification under instead of business, light retail, office. Why not have business, retail, office, and what would churches and
community services? I think
what do we call
community services?
Community services
falls under.
Have a classification for that.
Yeah.
Because there again, a church, you get into parking. It's
Mhm.
great if you have one service. You go to 2 services where you don't have enough parking. Because at some point, you got people in both services in the parking lot. And that you got to play around with that. Where do you want to draw that line?
Right.
Now, I'm not saying that poetry at this 10 seconds or in the foreseeable future need to worry about multiple services at a church, but that's what you end up getting into eventually. So we need to decide kind of, and I'll do the research, find out kind of what's the median, again, commercial property, general commercial, non-restaurant property. It's about usually 5 to 1, 5 spaces per 1,000 feet of building, heated and cooled building. You get into restaurants, generally most towns is 10 to 1. There are some towns, I think Plano is different, and I know Addison was different. They're like 12 to 15 per 1,000.
Why would that apply just heated and cooled? Let's take, for instance, Forney and all the quote-unquote antique mall buildings.
The big
Most of those
lots.
over there are 10 to 20,000 square feet or more, um, with no HVAC.
Mhm.
So you'd have to be careful how you word all that too.
Yeah, and we'll do the research for that to figure that out. I mean, Lake Point Church is another good example. They like, I think, David, what on Saturdays they have two services, and Sunday they have two or three,
On Sundays we have two and two,
two
and
two
Saturday
in the morning.
two on Saturday. But
One during the week, don't you?
Royce City's the one that's already blown out. They start a Saturday service now.
Yeah,
Yeah.
but I mean on the same day where you have
Yeah.
one service behind back-to-back services, you've got to start playing around with that parking.
Well, and they probably don't meet. That's why the police are involved there.
Yeah,
And
yeah.
And the Spanish
Oh, a lot of
church-
it is.
And the Spanish church comes in at 2:00.
Yeah.
Hmm.
Okay, so now let's jump to I'll do the rewrite on that. And I think business, let's kind of keep it. I'll start putting some things together, but let's go back to residential. How do we want to handle or tackle residential? We have SF1, for lack of a better name. What do we want to do?
Wait, which point
Well,
are you on?
Anything residential, single family.
Well, we obviously have SF1, and we only talked about doing one other classification for the 1 to less than 5 acres.
Mm-hmm. And so let's talk about that.
And if we're going to call that SF2,
Yeah,
I assume.
let's talk about SF2. For now, call it SF2. And so, we've talked about, 1 acre being our bare bone minimum outside of grandfather.
Right.
Okay. Do we want to have different size classifications? I mean, do you go 1, go 2.5, or keep it kind of like where we are?
I'm in favor of just doing 1 acre. I don't like the 2.5. That's, as we've found this last year, getting to too many problems. Just keep it at 1 acre. It's just a lot easier to interpret.
we talked about keeping the 1 acre because of going back to deed restrictions and things you talked about before. People that have the ability to subdivide.
Mm-hmm.
1 acre gives them, most people, that ability. Some
Yep.
people, not all. But
Well, let's talk about it. So you're saying 1 acre
Yeah.
minimum, or just have one classification,
Yes.
and you can do anything you want over 1 acre.
Essentially, yes.
Okay.
With the other things that we have, we have setbacks and all this other stuff. But
the setbacks will be complicated with one classification, though.
Yeah,
That's the only problem.
And by the way, 1 acre is gross, not net.
Correct.
Correct.
We will change that.
Yeah.
Well, what I'm going to do, I've been looking into that too. We're going to, we can say gross and net, but we're going to have a description of what that means.
Yeah. I think we went through that a couple meetings ago.
Yes.
Yeah, we did.
So how would we address if we use one classification?
Well, then, in other words, if we want to go back and say do an estate lot, I mean, where we get into it, where do we draw the line now that we're changing ag? Basically in ag, you can do anything you want, but it's got to be ag. What happens to the 5 acre guy, the 10 acre guy, the 18 acre guy? What do we do there?
Well, most of it, or a big part of it, is in ETJ. So it's, even though I have 5 acres, I only have 2.5 roughly in the town.
Yeah.
The rest of it's ETJ.
Yeah.
I'm sure yours is the same. It goes back.
Out of the 8, I don't know. Maybe 3.
Mm-hmm.
So that's why, you know, based on our experience this last year, resolving things is hard enough. Just do 1 acre.
Well, the setbacks for all of them would be the same essentially,
Yeah.
from the roads, from the sides, from the rear. You just have to be cognizant of the lot coverage because it affects the 1 acre the most.
So do we? So if we did, let's just walk through it through our brain here. So if we have just a single family 2 is 1 acre or more, we're gonna anything less than 1 acre is gonna be the grandfather, or there's because it's a lot, it's closed,
Right.
so you can't have anything less than you can't create anything less than an acre. The smallest you can create is 1 acre, and then so how would the 5 acre guy, the 10 acre guy, the 8 acre guy, how let's troubleshoot that. What's the worst case scenario? Somebody wants to do what?
Well,
It's do we have do maybe, and the other thing is maybe we raise the minimum ag to what to something larger than
Well,
5 acres.
but there's very few 5 acres inside the town.
There's
A few, but very few.
no, I mean Grand Verde has them. Hidden Oaks has a lot of 3, 4, 5 greater than 2.5 acre lots.
All inside the town.
Well, yeah. Well, not all. Not
Right.
all of the lots are not
Right.
the complete lot. No,
Right.
but there are. And but again, that leads to the next question: do we still keep our mother track definition? Play off of that, because that's our problem. I mean, in a normal town, your entire lot is in the city. Everybody.
Well, I mean, we all know that the problem is
Yeah. So,
the
but
geographic layout of the town.
yeah,
But
but
that's the way it is.
but how do we
So,
deal with it?
But well, that's my answer is to keep it really simple. Go to
1 acre.
1 acre. Don't get into. Now, I understand your issue about agrarian, because you know, there are things, and there's people that will have 5 acres inside the town. Very few.
Hmm.
But other than that, just keep it at 1 acre. And if they want to, if they have 2 or 2.5, want to split it, as long as they meet our other requirements, well, they're free to go.
Okay.
So that's why I don't like the SF2 or the SFE with the 2.5 acres.
Okay.
I like it just 1 acre.
So I think at this point, because that's a radical change to the zoning ordinance.
Yeah, but Dale,
No,
I'm
I'm not
I
disagreeing
didn't think
with
of
you.
that.
Yeah.
Frankly, back in 24, I only thought about it this last year when we're having to deal with these issues. I mean, there's a lot of things I didn't like. I was against the zoning all along anyway.
Yeah.
Okay, I didn't like the
Yeah.
zoning,
The
but
zoning committee
I
did
understood
like
why we had to have
that.
it.
Right.
So, and having all of this, which I didn't vote for, but I didn't anticipate the problems that we're seeing this last year
Oh God.
until we got into them.
Oh yeah.
And so now I said, and it's not everybody on the council has seen that. So I'm saying, let's keep it to 1 acre.
Okay.
And that
No,
makes it,
and I don't disagree. All I'm saying is because it's such a radical change in this zoning ordinance, why don't we take that question to council?
well, I think all of it will go to the council.
Well, I mean, before we try to write it. In other words, all right, council, this is what we're thinking: 1 acre, and kind
Well,
of get the pulse.
I guess I'm of the opinion of put it out there and let them take shots. If they have something on paper to shoot at.
We're open to discussion.
Well, that's generally what I like,
Yeah.
is put it on paper and let them take
Yeah,
shots.
you know me. I like a good fight, so I don't mind putting it out there. Huh? Say that
Hey.
again.
Yeah.
Hey, I'm having fun with this.
And it,
So what do
it
you
still
think?
goes back to the confusion of you just brought up mother tract, and I thought, well, we talked about striking that completely anyway. But then, you know, and that's what this is all based of: 2.5 acres of the mother tract. And it goes to the bottom line: what are we zoning? The little strip that we're zoning, it's just extremely confusing, even though
I agree.
We talk
Yeah.
about it over and over and over. What are we actually zoning? Are we zoning this 1 acre that is 1 acre in size that extends
That's
beyond
attached. Yeah.
the into the ETJ?
Yeah.
Or are we just zoning? Yeah, I know what we're zoning. We're just zoning just within
Well,
the.
we're struggling with how to deal with it.
This made it sound like we're zoning ETJ, but
Yeah.
the original. So when you say, what about the 10-acre guy and all that? Well, what are you talking about?
Yeah.
10 acres total?
That's the
Or
struggle.
10 acres?
Yeah, this way. Yeah, that's the struggle.
So,
Is do you know? One day I'm all for using the mother track reference, and then other times I'm saying, man, that's not going to work. Let's just keep.
but
it
mother
down.
mother track insinuates that you're zoning ETJ land. Is what what it sounds like to me.
I get it, but we can't zone ETJ
Right.
land.
That's
We
why.
can't, but and that again, it would go back to a legal. Once we do the ag, it'll go back to the legal opinion of because we can skirt that with the contiguous property scenario. If that, I mean, I've got 10 acres, and I bet I don't have 2 acres in town. So would the skirt be? And that's really was the real. And understand, I came up with the mother track when we were struggling with it in the first committee. Is how do we look at that piece of property versus another piece? Well, let's look at it from a mother track standpoint, and it did kind of help us sort it out. But you know, can we write a definition that would skirt that if it is if the contiguous tract and ignore it? That portion of a large tract of land is, if a portion of that tract is in the town, the zoning only deals with what's in the town, but it will affect potential zoning. Or do we do like you say, you know, SF2 and ag? But on a 100-acre tract, how many acres are in ag?
Very, very little in the town.
Very, very little. Yeah. So
So
that's
why.
and today is, I mean, again, the way I'm throwing it back out there is we got to chew on that. It's a head scratcher. How do you really deal with this?
Well, okay, you see my recommendation.
Mm-hmm. I'm okay with the 1 acre, Tom. Be honest with you, because in many ways it simplifies the big. I mean, if everybody's only got an acre or two in town, then maybe an acre is the better thing to do because it makes more sense.
Well, I'd say anybody, Dave or anybody
We're all
that's
that
having
way.
to try to resolve these zoning disputes would go to the 1 acre and get rid of the 2.5. Nobody in their right mind would want to deal with that
Yeah.
extra problem.
Well, and 2.5 acres now in poetry. What is that? $100,000 at least.
I don't know, but I mean, I think I have 2.5 acres in the town and 2.5 acres in ETJ.
Yeah, because you're on a corner. Yeah.
Right. And so, yeah, I just soon have it 1 acre and get rid of all the other things.
Minutia.
Yeah, because actually 5 acres, I mean, I guess I'm SF because I don't have 5 acres in the town.
Mm-hmm.
Now, Dale Jack may have 5 acres in the town, but very few others.
Well,
would.
you got to have thousands of.
I'm
hundreds
zoned
of
ag,
people.
and I don't have 5 acres in the town.
No,
You don't. I mean,
I'm ag too.
but
And-
Dale's got that long strip, so
yeah,
he
you
may
got, if you get.
may actually have 5, but this would be one of the few.
Oh yeah, I bet. I mean, I bet you have to have 50 acres to get 5 acres. in
Well,
the
he
town.
says 40 something.
Okay, but if you got a
Anyway,
lot of road frontage.
Anyway, that's my recommendation. It's just
Okay,
go to 1
so-
acre.
So what we're going to draft up for next month is 1 acre, SF2, 1 acre,
Right.
and ag, and I'll change ag.
And that's,
And let me play around with that. I don't know how successful I'll be, but I mean, again, this is our first stab, so it's first draft.
and I'm also in favor of getting rid of a lot of the other on the ag that you had, that you were saying, shorten that down, get rid of a lot of those things don't really mean anything.
Right. Yeah, I'll get rid of. I mean, and the other thing, yes, we are making things more complicated, but there's a lot of fluff in there that we can get rid of. You know,
Mhm.
like all those churches and schools,
Yeah.
all of that. We'll just
Well-
make that a separate classification and
Well,
let
for
it
all
alone.
practical purposes, the churches are the churches. Um, you know, and by the way, this is Poetry Springs. That's in the town, I think. Poetry Springs, that event center.
Right behind
no,
Jeffy's place.
it's not.
Is it
It's
not?
not in the town.
No, I don't think so.
Oh, so that's one of the.
Because it is.
It's 2426, isn't it?
Yeah.
It's up here.
So that's outside the town.
Yeah, it's in the ETJ.
Okay.
But I think, let's see, you come. Let's
Yeah,
see.
that's Jeffy's right there. So it's
Mike is here.
It's right,
Yeah,
right here. That'd be the building right there, isn't it?
yeah, yeah, here.
So it's past Mike, but out
Oh,
in the
yeah.
ETJ.
That's what it looks like.
Yeah.
Okay.
All right. So with that, anybody want to y'all want to take some stabs at looking at some definitions, write some definitions for the next?
Well, we had several we went over last time. You know,
Did anybody draft anything up?
I didn't any new, but we had the ones we marked up last time.
Yeah, we got 10 minutes. Which ones we want to? We talked about an acre,
Yeah, going
Yeah.
to gross.
and I think we kind of got that one done, right? Add a governed by a legal
Yes, that one's done.
description or survey. Okay, so we're gonna.
Oh, and there's another one too. I've got it in a different place. Here.
All right, here's one that bothers me: the definition of family.
Why is that even in there?
Huh? But it's only 4 people.
Yeah, I had some edits on that one, Dale. I know I did. I
Yeah.
turned them in or raised them that couple meetings ago when we were talking about it. I had a problem with that too.
How? I missed that. That's just
Family, I know. Here it is.
Yeah.
4 persons.
Yeah, one or more persons related by blood, married, guardianship, or we added guardianship or
How do we want
adoption.
to regulate that?
But how can you? I mean,
can't.
say that it's all fine. You're defining a family, but the 4 persons is
Now
absurd.
enforce it.
Not to exceed 4 persons. Yeah, I don't like
Are we
that.
trying to? But it says related by blood, so it's like you're trying to limit multi-generational type living or whatever. But it says related by blood, marriage or adoption,
Yeah,
blood, marriage or adoption. So it's not.
but I don't think you can say 4. I mean,
I don't think
No.
you can either.
No.
Does somebody want to take the definition of family and look at some bigger towns?
well, I'll say this: I go to the Catholic Church, and I think 4 would be exceeded real quickly.
When I was doing that survey, there's a family here that's got 9 kids.
I
I have a guy that works for me that has 6.
I'm not surprised.
Great family.
I
but it's
see him come in, and I go to the one on Saturday at 4, which is just the people that look like us.
Mhm.
They don't have many kids.
Yeah.
The people, if you go to the one Sunday at
Yeah.
midday or the 2 o'clock Spanish one,
Yeah.
man, they'll take up a whole row.
All right. Does somebody want to do some research and write a definition for family, or do we just get rid of it?
I would say take out not to exceed 4 persons. And
Well,
then,
if somebody would look and let's see what other.
What's the purpose
towns
of
are
having
doing.
family? The word
It-
family in there is just because we're trying to
Yeah.
just because we say single family, you have to have the family. You
Yeah.
have to define the word family.
And the other thing, what we may look at is let's maybe look at a definition for family unit. I bet there's a definition for that that doesn't get into the number and the
yeah,
ethnicity.
yeah.
Well, and we talked about adding a new ag definition.
Yeah, we need new ag. Anybody
Fence.
want to work on that one? I may have one. I found a really pretty good one, and it's pretty short and concise. for ag. I'll bring that next month. Any other definitions y'all would want to work on? Anybody want to take family?
Yeah, I can look at family.
Okay. I'm putting your name.
Send me a reminder.
Tom, which ones you want to look at?
Oh, well, I went through the ones that I had real problems with, which was that and acre. And I don't think I had, I mean, I've already been through them.
Okay. Yeah.
It's been a month or more than a month ago, 2-3 months ago.
Yeah.
And
Now-
those are the ones that, oh, yeah. One main, no. Yeah, the big ones that I had was acre and then family.
Okay. Now, there are some problems with our manufactured housing and manufactured home definition, along with HUD code manufactured home.
Yeah, I had printed some
That-
stuff on
There needs to be a better,
that.
there's a better separation. That sounds like the same thing. And I know it's all about the 1976 change in the standards.
Right. But you had different classifications. I mean, this is relating technically to a single, double, triple, wide type structure, not a what you
Now, is that ours or that's, what do you read?
Yeah, this is the towns right here.
That would be a good one to somebody. And another one to start thinking about, because I think we're going to have a long discussion on, is home occupation.
Yeah, I've tried to make sense of that. A gainful occupation, pedestrian. Yeah.
Wait a minute, where do you see that?
It's on the
oh,
same
I see.
page, right
Work-
above in the H,
Home
Work from home.
work from home, because that's a big deal now.
Oh, yeah.
Everybody works from home.
Well, essentially, you're saying that working from home shouldn't be a problem,
I don't have.
but is it a problem if you open up that auto repair business in your shop?
Yeah, I agree. If you're working in a bedroom at
But
home, you're not changing the.
But it says that. It says residing in the premises and conducted entirely within the dwelling or its accessory building. Now, I guess you could say, well, what about a person who lives in the garage,
Yeah, works out of the garage.
works out of the garage and has a mic over on 276 at 1565 mic, the Instigate.
Yeah.
Yeah,
Mike James.
Mike what?
Michael
Mike
James.
Yeah, Michael James. Yeah, he lives back there. At least he did.
He lived up front. He's since moved, but
Oh, he
yeah,
did. Oh, okay.
But yeah.
Well,
he used to
anyway,
live on
yeah,
premise.
people might do that.
You walk into his shop and his bed is over.
Bedrooms back there.
Yeah.
Well, and that's the kind of problem I have. It's like you say, like I know people that they're working out of the garage. Now the garage door's open all the time. And now we're going to go to an acre.
Well,
Yeah, I know.
Lumpy's over here.
Yeah. Now he's grandfathered in, but I mean,
Yep.
do we want to where do we want to draw the line?
On the less restrictive side, just because of what we're trying to accomplish here.
Mhm.
You can't. I don't think you can get too deep into it.
So once you change the appearance of the home, all bets are off? Kind of
So-
a thing?
I mean, if you build, and I see this a lot, build a barn dominium, and a large portion of that barn, because we have the definition of a garage, but it says garage private, but you could say this is your private garage,
Mhm.
but it could be 2,000 square feet.
Mhm. And,
My attached garage is 1,100 square feet. You could
Right.
do business in that space easily, but building trends these days are to build. People will build a barn dominium type structure,
Yeah.
and then have several thousand feet of quote unquote shop space.
Yep.
So and it's
and
attached.
yeah, and 800-foot apartment.
I've seen
yeah.
that too.
Well, I guess I don't have any problem with that, the home occupation, the way it's written.
Oh, yeah.
I mean, there's always, you can't stop somebody coming in
Sure.
because for one thing, we, as you said, we don't have enforcement anyway, but I'm okay with that. That's not the big ones were the two that I mentioned, acre and then the one on family.
Okay.
And I mean, in the way this is worded, I mean, the primary use has to be residential,
Yeah.
and secondary is the occupation.
And do
So
we allow signs in home occupancies, in home businesses?
that I would say no.
We have a signage.
Yeah, there's a paragraph.
Sign
about
ordinance.
Signage. We want to allow that in.
I would say that would be limited to commercial property, commercial zoning.
So probably we need to expand signage then, because we have a 64 square foot max on signage, 10 foot tall.
Yeah.
You want that in your neighborhood, you know.
I wouldn't think so.
Well, I don't.
It's again, I'm throwing this stuff out. This is all kind of stuff to be thinking about. 'Cause we're gonna have to cross these bridges.
Well,
You know. We
yeah.
gotta
I
get
mean,
there.
we went over that signage. We've gone over it before. And I guess
We talked about I don't know what got us onto that, but yeah, we talked about it. But this is a different application of signage
Mhm.
that might need to be addressed.
Yeah. Because yeah, there's a lot of people that work at home, no signs, but there's going to be some people that are going to want signs, and that's why I think maybe when we kind of figure out get comfortable with this definition, and then look at it from a standpoint. Now let's expand signage. Do we really want that big of a sign at somebody's house?
I don't advertise any of my
Yeah, I don't either.
businesses on.
I don't either. But
on the
let's
street?
say you're doing barbershop.
If you're doing it out in the middle of the country, then people need to know where to go.
Yeah, Yeah.
It's fine that you do it.
yeah, yeah. But there's where do we draw the line?
Yeah.
You know, and maybe we just for home. Because again, let's say you have a metal building in the ETJ and you're running your business out of there.
which,
How
by the
big was-
way, we're getting to something. You know, I think we'd already added this issue of morals. I offered a definition of what morals is.
morals. Yeah, I agree.
Because-
That's a good one.
You know, signage. That clearly gets into signage. Is that you know, we
Yeah.
don't want somebody putting up a sign in the town that has something that's
Yeah.
bad implications.
Yeah,
So anyway, and that wasn't in the original definition. We added that
Moral.
one of the first
do,
meetings.
do
I
we
think.
have a definition of morals?
Yeah, I added it.
Okay.
It is refers to sexually explicit businesses, organizations, and advertising.
Is it in yours?
Yeah, we added that one of the first meetings.
Okay. Well, this is I'm looking at the version from 324. No, that's that one.
32124.
No, yeah,
That's the one I'm looking at.
that's the first one. But I don't see morals.
Okay,
In
well,
mine.
32124 has in.
Yeah, I don't have a problem with it. I'm just saying mine doesn't have morals.
This is on pages 11. Yeah,
11.
I think Scott did it. I think.
No, manufactured housing, mobile home, and then it jumps to non-conforming.
Yeah, I don't have it either.
Yours doesn't either. I think this is
It's
you've got the original. This is a draft. This is this is one of our drafts. What you're
I
looking
think
at,
Scott did this one.
and I'm looking at. And that's why we got to get this at the bottom of the page. We got to be careful, get that cleaned up. That we know which version. That's what I did. I printed out a different color so I know which one to look at.
And then, by the way, while we're doing it, and hopefully this got in is over on page 1, or page 2 on 1.3. We took 1.3 and 1.4, we took out the words
Yeah, that's-
territorial jurisdiction.
Yeah, see, I've got it, we've got it
Okay.
underlined,
All right.
taking it out.
Yeah, that was one of the first things we
Yeah,
did.
first things we did. And I think it's good sometimes that we leave these strike throughs in the document
Yeah, I did too. I don't have
So-
any problem.
so that people can see. Because no one's ever going to take this and read the original and do this.
Yeah.
So, all right. So we have enough to work on for next month?
Yeah.
Okay. But we are going to be talking about this, I think, in June. June meeting.
It's going to add it to the agenda.
Yeah, I think Mike has already had, we talked about it, already added it to the agenda. Just give a report, and if we need to give an update or report, feel free to, if you want to talk about that, you're more than welcome to take that part of the June meeting, talk about progress in the zoning committee.
Well, it's your committee.
No.
You're the chairman.
But we're councilmen, we're both councilmen, so
Yeah,
it's
well,
as
no,
much as
I
yours
don't mind
as it is.
adding my points.
Yeah.
Um,
So, you want me to tell him to, let you speak on that subject?
well,
I don't mind.
Yeah, I mean, you
Yeah.
should too. 'Cause
Okay,
a lot of this is yours, so I don't mind speaking up and filling in the blanks.
okay.
So
All right.
turning them off?